Well, thank you all for taking your seats, and we'll begin our panel. I'll actually start with an email from Chuck Newman, who was a fellow from 1972 to 1973, who couldn't be here today. That class includes, well, among others, Liz Schneider, who is here today. Chuck wrote to say, "It is truly astounding to think that the Hayes program is 60, but not hard to understand, since its work has earned its longevity, and the need and value of the program have been proven and redoubled with each year. Our panels this afternoon underscore the continued need for the Hayes program and for the extraordinary lawyers, Norman and Sylvia, and the program, and I hope the program in future continues to train. Certainly a great deal is under assault, as Steve Shapiro underscored this this morning. Our first panel focuses on the Constitution of Equality and will address issues of race and gender, economic justice, and voting. And to lead the discussion, I turn to our moderator, Natalie Gomez-Velez, who was a fellow from 1988 to 1989, and other people in his class, Ricky Blum, who I know is here, Malika Dutt, Robin Abrams. The program, which you all have, lists her many accomplishments and honors, and so I'm not going to recite them. I'll say only that I first met Natalie a long time ago at the ACLU, and I've continued to stay in touch quite closely because my husband works with her. They teach together at the City University of New York Law School, and so I know how valued she is for her inspiration and for her sagacity and for her patience and for her kindness. And so I turn the panel over to Natalie. So thank you.
Thank you so much, Helen. That was really nice. Again, my name is Natalie Gomez-Velez, and yes, 1988, 1989 Hayes program. I have to say a lot of time has passed since I was a Hayes Fellow, and much has changed. You know, I have to just say this, in the time since I was a Hayes Fellow, I feel fortunate to have experienced, you know, seemingly meaningful progress, right, in civil rights, civil liberties, and social justice, right? There were setbacks, of course, along the way, and we were talking a little bit about that when I was speaking with Helen, and I can vouch for those fights that went on about economic inequality and at the ACLU. But there was a sense of real forward progress. Today, much of that progress seems fragile, if not illusory. For example, I recall my work as a Hayes Fellow with David Cole at the time, a little bit at CCR, with Sarita Rios, who unfortunately is no longer with us. She was working on issues involving educational equity for Native American students. I worked with her on that. I worked with Ann Pillsbury at Central American Legal Assistance, advocating for asylum seekers from El Salvador and Guatemala. And that work, I recall, was accompanied by a deep sense of care and concern for the plight of people in crisis, right? And over the years, you know, there were moments where it really felt like thoughtful humanitarian immigration policy seemed possible. And now, however, much of that, as you all know, is in serious doubt. Indeed, the current climate and treatment of certain immigrants is nothing short of horrifying. I mean, we know what's going on at the borders. Similarly, progress on equality and justice involving issues of race, ethnicity, class, gender, even the structure of government itself, all seem at serious risk. That some say that progress is being erased. And we heard enough about that this morning, right? So we really do have our work cut out for us. But I will say this, there is indeed reason for hope. And a significant part of that reason involves the panel of Hayes alums that are right here at this table and you're gonna hear from in a moment. Each of them is doing spectacular work, demonstrating that continued progress is not only still possible, but is occurring right now. I will introduce them very briefly just so you know, well, you have their names up there. I don't even have to do that, but I'll state each of their names. And each will speak for 15 minutes, followed by, and we really do want an opportunity for questions and answers and discussion. So they actually agreed to have, like, we'll speak for 15 minutes so that we leave time for questions and answers. Again, the theme is the Hayes Program and the Constitution of Equality, and with a focus on race, gender, and LGBTQ rights, as well as economic justice and voting. And so let me introduce to you, again, their bios are in your panel. With us we have Anjana Samant, who is Assistant Attorney General in the Civil Rights Bureau of the New York State Attorney General's Office, and who will be actually changing to a position coming in December to the ACLU's Women's Rights Project. She will be talking about race through the lens of the Muslim ban. Gabriel Arkels, Hayes class of 2004, is a senior staff attorney with the ACLU's LGBTQ and HIV project. And he will be talking about the Harris Funeral Home case and other issues. Just a little note in the program, just wanted to mention that he was at the Prisoner Justice Initiatives at Sylvia Rivera from 2004 to 2010, a little longer than is issued in here, so a small correction. Susan Shin, who was Hayes 2006, Legal Director, New Economy Project, will be talking about economic justice, and Ian Vanderwalker, Hayes 2008, Senior Counsel for the Brennan Center's Democracy Program, talking about voting rights, the state of voting laws, et cetera, which we know is something that is critically important always, but particularly at this moment. Please join me in welcoming our panelists, and we're going to start with Anjana Samant.
Good afternoon, everyone. So I'm going to be talking probably way too fast to try to cover a little bit of information. I want to start with a short discussion of how the New York Attorney General's Office got involved in the litigation challenging the travel ban, and then also just take a look back at some of the key constitutional cases. And the theme here really is about how history repeats itself, echoing, I think, a lot of what Stephen said this morning, but about how the fight for equality is an ongoing one. This is going to be a constant process, and not a place of arrival for us. So the travel ban started shortly after the election. 4 days after inauguration, President Trump issued a draft executive order. And then on Friday, January 27th, the official first executive order was issued. As a brief reminder, what it basically did was ban entry for 90 days by citizens from 7 Muslim-majority countries: Iraq, Syria, Iran, Libya, Somalia, Sudan, and Yemen. The order also indefinitely actually halted refugees coming in from Syria, and then also put a temporary ban for 4 months of the admission of all refugees. There were other provisions as well. As events unfolded on that Friday evening, it was pretty clear that implementation was hardly consistent. Things were chaotic, to say the least, here in New York, in JFK, at Chicago O'Hare, at LAX, all over the country. Among other things, initially it appeared that the ban would actually be applied to both legal permanent residents and visa holders. And it was unclear whether it would apply to dual citizens. So people who thought they were guaranteed admission, or at least based on their documentation, the process that they had been through, suddenly were finding themselves, as they deboarded planes, being either denied entry, being delayed in the airports. And as advocates gathered on Friday night and the first lawsuits started to be filed, on that Saturday, former NYU immigration law professor, now at Yale, Mike Wishney, and his immigration law clinic filed for an emergency TRO nationwide, along with the National Immigration Law Center, and also the ACLU Immigrants' Rights Project in the Eastern District of New York. On Monday, the Attorney General for the state of Washington filed a complaint on behalf of itself as well as, I think it was the state of Minnesota at the time. At the AG's office, we spent the next few weeks basically gathering evidence and affidavits from impacted individuals, businesses, schools, organizations, all in support of our claims that we intended to bring based on the argument that as the state, we were injured both as in a parens patriae capacity for our residents in our states, but also the state itself was being harmed. We have public universities, we have hospitals that serve underserved communities that are disproportionately staffed by foreign trained and non-citizen doctors and nurses. We basically put together, in a record amount of time, a ton of information, thanks to a lot of networking and fact-gathering that community organizations did for us. And we ended up filing to intervene in the Eastern District lawsuit in February. A few weeks later, we moved and joined the Washington case that was pending before Judge Robert N., along with a few other states. The litigation history of the travel ban is way too long and convoluted for me to really go into it in detail. So what I'll basically say is Travel Ban 1 was issued. It was then withdrawn once, rewritten twice, reissued, and then enjoined at least 3 times by lower courts before it made its way up to the Supreme Court. I'm going to jump forward to September 2017 when the third travel ban was issued by the Trump administration. The third travel ban placed restrictions on residents and citizens of Chad, Iran, Libya, North Korea, Somalia, Syria, Venezuela, and Yemen. And the reason this time that the administration gave for selecting these particular countries was that allegedly DHS and other federal agencies decided that they would only allow in individuals from countries where the countries could confirm certain baseline criteria or information about individuals who are seeking visas or otherwise trying to visit the US. Among other things, one of the issues was, can these host home countries actually confirm identity, provide documentation, clear criminal background checks? Also, interestingly, the new list of countries included 2 non-Muslim majority nations. Regardless, in most instances, basically with every single one of these countries, most travel would be suspended, and in a couple cases, travelers would basically just have to go through enhanced screening and vetting. April 25th, 2018, the Supreme Court heard oral argument on the ban and focused on 2 issues. One is whether the travel ban fell within the president's authority over immigration, which in part includes, pursuant to statute, allows the president to suspend entry of immigrants for a period of time. And 2, whether the proclamation, actually the third executive order was actually issued as a presidential proclamation, but violated the Constitution's Establishment Clause by favoring one religion over another. In the litigation that the state attorney generals brought, as well as advocates and individuals, there were a variety of other claims, procedural due process, APA claims, obviously equal protection claim was a big one as well. The decision actually came out finally in June 2018. 5-4, the High Court found that Trump's action was actually squarely within the scope of presidential authority, and they rejected the argument that it discriminated against Muslims or otherwise exceeded his authority. The decision written by Justice Roberts said, among other things, when it addressed the issues of anti-Muslim bias, which throughout the lower courts had been presented in the form of campaign statements, tweets, official post-election and post-inauguration statements by Trump as well as other high-level officials, the majority basically listed a number of these explicit statements that the president and advisors had stated over time that connected the prospective travel ban with animus towards Islam and Muslims, but then concluded that it wasn't the role of the Supreme Court to denounce these statements, only to determine the significance of those statements in reviewing a presidential directive that, neutral on its face, addressed a matter within the core of executive responsibility. Justice Sotomayor wrote a scathing dissent, citing, in large part, Korematsu, and the majority actually distinguished that case on the grounds that the travel ban was actually a facially neutral policy that was denying people the privilege of entry into the country, whereas in Korematsu, Japanese internment was clearly a forcible relocation of US citizens based expressly on race and only race. And in the same breath, the majority basically overturned or at least endorsed the invalidity of Korematsu, saying that it's objectively unlawful and has been ultimately rejected in the court of public opinion, at least. Just as a quick reminder about Trump's rhetoric, among the other things that he said during in March 2016, so this was one of his statements while on the campaign trail, I think Islam hates us. We can't allow people coming into this country who have this hatred of the United States and of people that are not Muslim. In February 2016, jumping back, he actually asked Lieutenant General Michael Flynn, who later became his national security advisor for a minute, to advise him on a bunch of issues, including national security and foreign policy. The same month, Flynn posted the following message, or tweeted rather, as follows: "Fear of Muslims is rational. Please forward this to others. The truth fears no questions," and included a link to a YouTube video that argued that Islamophobia was an oxymoron. Later on the campaign trail, Trump stated that I think Islam hates us in an Anderson Cooper interview, and the list goes on and on. Nevertheless, the court found that there was no constitutional infirmity, and the issue of bias, they weren't even going to get into it because of the president's plenary power. So I'm going to switch gears and do a quick little story. Imagine a woman named Jenny. She came to the US as a Bay Area employee pursuant to treaty rights between the US and her home country, which allowed nationals to come to the US and work even though it didn't create a pathway to citizenship. About a decade later, as relations between the government and the US soured, the US passed a law basically saying no new workers from Jenny's home country could enter the US, and people already here could stay if they could find someone, a white citizen, basically to endorse the legitimacy of their presence. And also people who left and returned, if they could get proper documentation from the federal government, they would be allowed back in. Jenny leaves to go home, comes back about a decade later. She actually, before leaving, did get paperwork from the US federal government, got permission to come back, but unbeknownst to her, between the time she actually left her home country and got to San Francisco, the Congress had actually said, you know what, that whole thing that we said about getting proper documentation will let you in, just kidding, that's no longer valid. So she gets to California, and then Customs doesn't let her back in. Story sounds very much like something that probably would have happened under the travel ban, but this is actually the story, the facts underlying Che Chan-ping, who came to San Francisco as a laborer in 1875. He ended up contesting his exclusion, as did two others similarly impacted, and the trio of cases came to be known as the Chinese exclusion cases. The Chinese exclusion cases have been attributed with kind of really setting forth the contours of this plenary power doctrine that gives the president and Congress, but really the president, plenary authority in matters of immigration. And one of the things that's really interesting about the case is actually the factual predicate for the court's conclusion that the immigration policy in question was not unlawful. Ultimately, they ended up holding that whatever rights non-citizens may have had, they certainly did not have the right to challenge the president's and Congress's decisions regarding entry and exit. In reaching those conclusions, the court actually talked about and described Chinese laborers as foreign and as aggressors who, quote, remain strangers in the land, who, as foreign subjects of another sovereign, threatened to, quote, overrun the US, They posed a great danger to the US because of their vast hordes, crowded millions, and aggressive encroachment within the US. And therefore, regardless, there was no problem with Congress deciding that because people happen to be of a certain race, if based on national security grounds they were a threat, they could actually be prevented from entering the country. Interestingly, just to the extent that the Travel Ban 3 had this whole thing about like, oh, we can't verify who you are, we're worried about documentation. This actually also came up in the Chinese exclusion cases. Although the validity of the plaintiff's entry certificate was not challenged, Justice Field at the time went on a tangent and cited widespread fraud as having given the government a legitimate rationale for limiting and then revoking the evidence, or rather revoking the certificate that would have permitted Xi Jinping to re-enter the country. One of the things that I also found interesting, and I'm going to be losing time, so I'm going to make this really quick, is that, where did these notions of cultural, racial, legal belonging come from? They didn't come out of nowhere. And interestingly, it's not even so much that they came from earlier immigration-related cases, but they actually come from Dred Scott, which I think also just speaks to not just how in popular culture, but actually in constitutional doctrine, race, immigration, notions of national belonging, notions of citizenship are just intimately intertwined. I'm almost out of time, so I'm not going to talk about Dred Scott, but in terms of the theme of history repeating itself, I think one of the things to keep in mind and that I find really stark is that even with Dred Scott was also a case about family separation pursuant to slavery. I feel like we're actually living in this crazy era when all those same exact issues are coming to a head. We have President Trump with the travel ban, and while that is over, that whole theme, this whole struggle for who we are as a country, who a US citizen is, whether legally and on paper or visually, is highly contested. And we're seeing same arguments that were made more than 100 years ago being put forth again, both in policy and in the press. So. Perfect.
I guess I'll get up too. All right, so I can't promise to be more uplifting. The last couple of years and also the last couple of weeks have been really difficult on many fronts, including the gender front, right? I think many of us are still reeling from the confirmation hearings. And then we just had the leaked memo about redefining the sex for purposes of various federal regulations. I know I'm still reeling from all of these things. What I want to talk to you about today is mostly this case, Harris Funeral Homes v. EEOC, because it's been my life for the last month or two. We just filed the OpCert on Wednesday. And because I think it also helps illustrate my main point, which is that the attacks on trans people are absolutely not separate from attacks on LGBTQ people, from attacks on intersex people, from attacks on women, from attacks even on men who don't match every single masculine stereotype in the world, right? And there's a ton that our opponents are trying to put out there to divide us against each other and to particularly situate trans people as a threat to cis women. But in fact, all of these struggles for gender justice are the same struggle. They're completely bound up with each other, and there's no way that any of us can win without all of us winning, right? So I'm going to talk to you about Harris Funeral Homes. So in case people aren't familiar with it, here are the facts. So Amy Stevens is a transgender woman, and she was a funeral director. She'd worked in the funeral homes industry for 30 years, and she had worked for Harris Funeral Homes for a little less than 6 years. At the end of that time, she told her boss, Tom Rost, that she was actually a woman. that she had been trying to hide it, but she couldn't handle it anymore, and she was going to begin living openly as a woman. And he fired her with no complaints about her performance. It was very explicitly because she was a transgender woman. Tom Rost had run that funeral home and its 4 locations for 35 years. In that time, he had never seen fit to hire a woman funeral director or funeral director manager or funeral director assistant. Women in his business were secretaries, a cleaning lady, in his words, and one office manager. Except for Amy, who he didn't realize was a woman until she told him, at which point he fired her. So Amy, this was under the Obama administration, went to the EEOC, and the EEOC decided to investigate. And when it investigated, it found out that there were some other problems, including, so Rost has a sex-specific dress code, and he buys the clothing that he wants the men to wear, but he requires women to buy their own clothing. Once the EEOC sued about both that and firing Amy Stevens, he started offering women a small stipend that was far less than what he spent on men. And in his deposition testimony and his affidavits, you'll see that he says, I'm just old-fashioned, I want men to look like men and women to look like women, I require all women to wear skirts or dresses, they may not wear pants, even though the industry standard does permit women to wear pants. I believe that your sex is an immutable gift from God, and it is wrong to reject that. I think that women are a strange breed, and we have to do things differently. He also, at one point, distinguished between his key employees and his lady attendants. So the district court said, all right, the disparate compensation for women and men, that's a problem. And it's also sex discrimination to fire Amy for being a transgender woman, obviously. But for that one, we'll give you a pass because under the Religious Freedom Restoration Act, because we think this is a substantial burden to your religious beliefs, and this was not narrowly tailored to the compelling government interest in non-discrimination. It goes up to the Sixth Circuit. The Sixth Circuit says, well, the district court was right about everything except that Religious Freedom Restoration Act stuff. This does not substantially burden your religious beliefs, and even if it did, this actually is narrowly tailored to compelling government interest in non-discrimination. And now the funeral homes represented by ADF, our friends at Alliance Defending Freedom, who are against us on every gender issue, have petitioned for a review in the Supreme Court. And the reason why I went over those facts in some detail is because one of the things that I find especially aggravating in a lot of aggravating arguments is that they actually say that they are defending the interests of women, that if Amy Stevens were allowed in the workplace, then it would push real women out of the workplace. And I feel like that is a sort of shocking claim when your client won't hire women as funeral directors and compensates women less than men, and the only person actually shoved out of the workplace was a transgender woman, right? Even representing this guy, they're still saying what we're doing is in defense of women, real women. We need to protect them from the threat of transgender people who may be in the restrooms, right? But shifting to the legal arguments a little bit more, so how do they say that this is not based on sex? So they say that sex in Title VII and similar laws only refers to biological sex. And to know what they mean by biological sex, you can look at the leaked memo where they say that by sex, what we mean is your genitals at the time of birth, or if there's ambiguity, your chromosomes. So they're saying this discrimination wasn't about genitals at the time of birth, therefore it's not sex discrimination. With me on their argument? Yeah. But then, and this is important, I think, they also say if you discriminate on the basis of real physical differences, like genitals at the time of birth, it's not discrimination. Okay? So just to back this up, so he has this dress code, right? women have to wear skirts, men have to wear pants. And while the EEOC actually didn't challenge the dress code, their defense is very much about the dress code. They say, well, the reason why we really fired her is, although they would never say her, is we require men to wear pants and women to wear skirts. She's a man, and she wanted to wear a skirt. That's not okay. And so they say, look, it's well settled that, in fact, employers can take sex into account. They can make policies that differentiate on the basis of sex, so long as it is on the basis of real differences, like genitals. So you hear these two things together. It's only discrimination on the basis of sex if it's about genitals at birth, but it's not discrimination on the basis of sex if it's on the basis of real differences, like genitals at birth. So I'm actually going to read to you a little bit. Sorry, I have to bring it up on my phone. Because I think this is actually this last part is actually even clearer in a case where you would think it would even be less relevant. So this is Altitude Express v. Zarda, which also the Supreme Court may be taking up soon, who knows. And this is a case where a cis man was fired for being gay. And so the Department of Justice under Trump argued on the side of the employer. And I'm just going to read you a little part of this transcript. This comes up, a judge is saying, from the Second Circuit en banc is saying, well, isn't this, how do you separate this from a situation where an employer say is okay with hiring Jews and is okay with hiring Christians, but isn't okay with hiring Jews who marry Christians? Isn't that still about religion? And the DOJ attorney says, unlike Jews and non-Jews, where there are no factual differences and the law does not recognize differences between Jews and non-Jews, I know, right, also? There are real differences between men and women, and the law recognizes real differences between men and women. And this is vividly illustrated by the situation with the bathrooms. And Judge Lynch says, so sex discrimination is sort of okay because there are real distinctions between men and women, but racial discrimination and religious discrimination are not. DOJ attorney says, that is absolutely the case. Discrimination requires treating people who are similarly situated differently. Men and women are not similarly situated in all respects. The same exact physiological differences that are relevant to bathrooms are the same exact physiological differences that an employer is allowed to take account of when they're regulating their employees based on their off-the-work sexual relationships, right? I had, thank you. I got chills when I was hearing this, right? I mean, not just because I'm an attorney and this is about a huge reversal in law if it were adopted, and not just because I'm a trans person. He's saying that I should not be allowed to use the restrooms, which means I can't go anywhere outside of my home. Not just because I'm a queer person and he thinks I should be able to be fired for that, but because I'm a person decided female at birth. And this is one breath away from saying women belong in the kitchen, right? It's like, it's not discrimination. It just emanates from the uterus. You just have to stay in the kitchen, right? That's what they're arguing. And I think so I think when we see things like the leaked memo, people are framing it as an attack on trans people, and it is. They are absolutely attacking us. And that is something that everyone should be up in arms about, right? But it's not just that. I think the reason why it's directed a little bit more at trans people and at LGBTQ people is because we're seen as somewhat more vulnerable, that people won't stand up for. But I think what they're really trying to do is to erode to nothing, or as little as they can get it, all protections against gender discrimination of any sort. And this is one of the reasons why I think, we have got to be in this together, right? Like there's no way to let these attacks go and have it not be a disaster for everyone. And the same goes in all sorts of different directions and all sorts of arenas, right? Thank you. So in terms of, like, like the defense of sexual violence, the attacks on reproductive rights. Like those are things also that are typically associated with cis women, but also have huge impacts for trans people, have huge impacts for LGBTQ people, have huge impacts for intersex people. And it's shocking and it's extreme. So I have 5 minutes left. And what I wanted to try to talk about with the last 5 minutes is just a little bit of where I think we should go from here. So there are a lot of different directions. And I don't think that any of them are wrong, and I definitely don't have all the answers. I've actually been staying up nights, like probably many of us, thinking, well, where do we go from here? But I have a couple of thoughts, and I thought I would share them. So one is that I think we need to keep doing what we're doing with some adjustments, obviously, in terms of impact litigation. We're going to lose a lot more, but even if it's about cabining the harm, even if it's about putting off some of the harm, even if it's about laying groundwork for another day, I think it's still worthwhile. I think we still have to do it. A lot of litigation, we may also be looking at, state law and state courts in those states where that's viable, right? Another thing is that we need to keep in mind, when we're talking about the definition of sex, people often think about the context where I'm talking about it, Title VII or Title IX. But it's hugely important in a wide variety of administrative contexts, and including access to benefits, including ID documents. And these things are life or death, including prison placements, right? Another thing we've seen the Trump administration do is try to walk back some of the Prison Rape Elimination Act, particularly as it regards trans people. So, I mean, those contexts are where people tend to be most vulnerable, and those are places where we need to be putting a lot of resources. I'll also say, I mean, impact litigation has never, ever, at any time, been the only or the most important strategy for social change. It can be a very important one, but it is not the only one. It is not the most important one. And I think especially in this moment when we're seeing, well, the courts are not looking so great for us, it's all the more important to do what we can to try to defend, support and defend other resistance strategies. And really, in these times, I'm thinking any sort of resistance strategies. I don't want to pick and choose or judge which ones are going to be most effective. I mean, I tend to think community organizing is especially important, right? But we're talking about service provision, that's important. If we're talking about armed self-defense, I'm prepared to defend that as well, right? If we're talking about people casting hexes or writing poems, fine, we should support that as well. Like people are creative, culture is a part of it, right? Survival tactics are a part of it. And I think that we should be trying to defend people who are using a wide variety of resistance tactics. That's part of the role that we can play as lawyers. Got it. And then I also think that it's already true that a lot of people are, especially a lot of trans people of color, but many of us, including women of color who are criminalized for so-called fetal endangerment, women who are criminalized for sex work as a survival strategy. Criminal justice has already been a system that's been very much used against our communities, and I think that's only going to increase. I think we can see more trans people who are going to resort to self-help and scratch out the gender on their ID and try to write in a new ID, and then we'll get charged with fraud. I think we'll see more people pushed into criminalized economies. I think we might see more people who are trying to self-induce abortion and are actually getting charged for it. So I think we need to pay careful attention also to criminal defense and see how we can add resources there. I think that we absolutely need to be building strong coalitions among ourselves because all of these issues overlap, right? And finally, I actually think we need to be, especially if we're thinking long term, we need to be thinking about climate justice in terms of all of this, right? So things are changing already, and they will continue to change more. And gender justice needs to be a part of that too, including, who are are trans women of color getting expelled from evacuation shelters because they're using the restrooms? Yes, the answer is yes. Who's vulnerable to sexual exploitation in times of crisis? What are the gender narratives around who's rescuing whom and how, and who's expected to do what sort of labor? When people are displaced, who has the wealth and resources to be able to relocate somewhere safely? What are the impacts going to be in terms of breast cancer? I think gender is a part of climate justice. It has to be. And what federal courts are likely to be flooded when. I mean, we need to take it into account in our strategies, especially if we're thinking long term. So that's what I'll leave us with. Thank you.
And speaking about other strategies, Susan Schiff.
Hello, everyone. I wanted to start by thanking Sylvia and Helen for inviting me to speak today. It's really an honor. I also wanted to thank Natalie for the introduction. And I wanted to say that we at New Economy Project are really thrilled about all the ways we've been connected with the HAYS program. We had a former HAYS fellow, Mason Pesek, intern with us last spring. We have a current HAYS fellow, Devika Balaram, interning with us this fall. We have 2 former HAYS fellows who used to be on our board, Pamela Saw and Clark Bruno. And 23 years ago, another former HAYS fellow, Sarah Ludwig, founded New Economy Project and continues to lead it today as one of our co-directors. So part of me just wants to say, what they said and then sit down. But I do want to talk about the approach that we've taken at New Economy Project to economic justice work, especially following what Steve Shapiro said, and just given all of the really important things that Anjana and Gabriel just said, I think it all is of a piece. So what we do at New Economy Project is to work with community groups to fight systemic inequities in our financial system and our economy that perpetuate segregation, inequality, and poverty, and to promote community, cooperative and community-led equitable development. So that's part of the institution building that Steve was talking about is sorely needed. So on the one hand, we're fighting against redlining, predatory lending, abusive debt collection, and on the other hand, we're working to build institutions that democratize and root wealth locally to promote, such as community land trusts, worker co-ops, and community development credit unions. And our work has always been grounded in racial and economic justice and premised on the fact that our economy is extractive and exploitative, and our political and economic institutions and processes are really structured to perpetuate segregation, inequality, and poverty. So at New Economy Project, we've focused our racial and economic justice work on the role that big banks and other extractive institutions and public policies play in shaping neighborhoods, and in particular, in redlining entire communities. As people know, the big banks have a long history of systematically denying loans and services to communities of color, i.e. redlining, which is illegal. So in New York City, you've got 50% of our neighborhoods that are neighborhoods of color. But those neighborhoods have only 22% of the city's bank branches. That's not to say, though, that the big banks have not found a way to extract money from these neighborhoods of color. They finance and often own predatory companies such as check cashers and pawn shops, and those are the high-cost predatory services that people in these redline communities are forced to turn to. So whatever profits those companies make find their way back to the big banks. Then there's also reverse redlining. So for years, as many of you know, the subprime lenders flooded communities of color with high-cost predatory mortgage loans, devastating entire communities and triggering the financial collapse and the foreclosure crisis. And banks fueled and profited from these subprime loans by selling them as investments on Wall Street. We've also seen that the big banks drive discriminatory practices in the debt collection industry. They market high-interest subprime credit cards to low-income communities and communities of color, and they profit from the high fees and the interest. Then they sell those old credit card debts to debt buyers, and they even finance the debt buyer's purchase of those old debts. And as our research has shown, these debt buyers disproportionately sue and obtain judgments against people in neighborhoods of color. So a few years ago, we issued a report with maps and analysis of default judgments all across New York State. And we found that the 10 zip codes in New York State with the highest concentrations of these default judgments were all neighborhoods of color where the population was at least 75% non-white. And 6 of those zip codes, the population was actually more than 90% non-white. And another really intriguing fact that we found was that of those 10 zip codes, 6 of those were actually middle-income communities of color in Southeast Queens, which are the same communities that banks have redlined for decades and that were really at the epicenter of the predatory lending and foreclosure crisis, which just confirmed what we had suspected, and I'm sure as many of you have also thought, that it's really not just about income, it's really also about race. So we've also seen that these systemic inequities are embedded in people's credit reports to the point that someone's credit history ends up serving as a proxy for race. And that's one reason why we formed a broad-based coalition some years ago with community, labor, and civil rights groups and waged a successful campaign to end employment credit checks in New York City. And this was because we believed that credit histories that reflect these systemic inequities should not be used to perpetuate these inequities by denying job opportunities to people of color. Unfortunately, these credit histories are still being used in many other contexts to deny opportunities to people of color in New York City, including housing, insurance, and credit, so those are still battles that need to be waged and won. We've also brought impact litigation against another discriminatory practice that drives people out of the mainstream financial system. Many of you, at one point or another, have probably seen fraudulent credit transactions or debit card transactions on your account statements. Hopefully, you were able to complain about them to your bank and maybe drew on your lawyering skills and argued more vociferously than you might have needed to. But in the end, hopefully, you probably got the problem resolved. At New Economy Project, we run a financial justice hotline. It's a free legal hotline for low-income New York City residents. Over the years, we've heard really exclusively from low-income people of color who have told us that they experienced fraud on their bank account, but when they reported it to their banks turned around and blamed them for the fraud. And to make matters worse, they reported them for the fraud to these agencies called bank account screening agencies. They're like credit bureaus, but for banks. And what happens when you're reported for fraud to one of these agencies is that for the next 7 years, you will not be able to open another bank account in this country. So without a bank account, these New Yorkers we've spoken to, they've had to turn to high-cost predatory products and services such as check cashers and prepaid cards just so they could cash their paycheck or pay their bills. So we have litigation pending right now against Bank of America and the country's 2 major bank account screening agencies, one of which, surprise, is owned by a group of big banks, including Bank of America. So we really have this 2-tiered financial system where the more money you have, the cheaper it is for you to do all of the things you need to do, like keep your money somewhere or get paid or pay your bills. And the less money you have, the more expensive it is to do all of that. And it's also much less regulated if you're inhabiting that tier. For many, many years, as we know, the banks have fought tooth and nail for deregulation. We've seen that they've won a lot of ground, and under Trump, of course, it's just getting worse. With all of these problems harming people, we're really aware that we need to fight these problems now so we can try to seek redress for people and also shine a light on these inequities. But at the same time, especially in this day and age with Trump as president and a completely gutted Consumer Financial Protection Bureau, we know that we can't just keep playing whack-a-mole. We also see this work, therefore, as helping us to make the case for why we need structural change, that institution building. So what we feel that we need to do is really transform our economy in fundamental ways. We want to build an economy, we need to build an economy that works for everyone, based on cooperative and community-led equitable development. And to that end, we have 4 core campaigns waged in coalition with community, civil rights, labor, and social justice groups throughout the city. One is our Public Bank New York City campaign, based on the idea that public money should work for the public good, not private gain. Right now, New York City deposits billions of dollars in Wall Street banks. A public bank would allow New York City to divest from these Wall Street banks that are investing in fossil fuels, private prisons, detention centers, wars, and that are actively harming New York City residents and communities. The city could then reinvest these public deposits to support equitable and cooperative development, for instance, by making low-cost loans and investments to support affordable housing, renewable energy infrastructure, and small businesses. Another of our campaigns promotes community land trusts based on the idea that housing is not a commodity, but a fundamental human right. As a co-founder of the New York City Community Land Initiative, we promote community land trusts as a way to remove housing and land from speculative real estate markets and thereby create and preserve truly affordable housing and fight gentrification and displacement. Through our Cooperation NYC campaign, we're working to make New York City a hub for cooperative economics. We want the city to become a place that promotes and brings together models of cooperative community-led development, such as community land trusts, worker co-ops, community development financial institutions, and other co-ops. And last but not least, we have a New York State Community Equity Agenda campaign. And this is because after many years of fighting predatory lending, fighting to keep it out of New York State, and just playing that game of whack-a-mole, we've developed an affirmative agenda to build community wealth and try to transform our banking system. Underlying all of this work is our belief in the idea of basic human dignity, that people should have autonomy over their lives and be able to live in healthy, thriving local communities. Thank you.
Thanks. I also want to say thanks to Natalie and thanks to Helen and Sylvia for inviting me. As your program tells you, I work at the Brennan Center for Justice on democracy issues, and I want to talk today about voting mostly. The theme of the panel is equality, and voting. Equality is obviously central to issues of voting and democracy. We have the principle of one person, one vote. But unfortunately, there are various ways that our political processes fall short of the spirit of that principle, some of which have existed since the drafting of the Constitution and some of which are new challenges today. So just to list some examples, there's the Electoral College. Our current president was not elected by the popular vote. So that's a sort of counter-majoritarian factor. Then, of course, the original design of the Senate gives much greater political power to people in and this has always been the case, rural states. So the Senate is sort of inherently gerrymandered, and we sort of saw an effect of this with the Kavanaugh confirmation hearing, where the 50 senators who confirmed Justice Kavanaugh represented 44% of the American population, and it's possible to get a 50 vote, to get something passed with 50 votes in the Senate with people who represent only 18% of the American population. Then looking at the House, where the gerrymandering is not written into the Constitution, but is an activity of state legislatures, gerrymandering has always existed, but now with computers and the voter file and the map drawing abilities, you know, they can draw a congressional district around your kitchen table. It's possible to completely lock control of legislatures with political control of the districting process. And again, Brennan Center analysis indicates that the currently in the House, about 16 seats of the Republican majority can be explained essentially by gerrymandering as opposed to the actual preference of the voters. So, and apportionment issues will get worse if the Trump administration is successful in getting a citizenship question on the census, which is obviously intentionally designed to suppress census responses by immigrant communities under the theory that then blue states will lose seats in legislatures, including Congress. So all of these factors are sort of leading to political control by a minority that is disproportionately white, older, and conservative, right? Not just any minority, but a specific demographic minority. And it's putting us in a moment where these manipulations of the political process by politicians who stand to benefit from them are obviously threatening the values of equality and representativeness in our democracy. So as I said, a lot of that comes from the Constitution, but some of it is relatively new in the last decade. And a key mechanism has been voter suppression, which is a way for politicians to pick their voters rather than the other way around. Going into this election next month, 23 states face additional restrictions on voting as compared to 2010. The most common of these is the strict voter ID requirements, government-issued photo IDs. That didn't exist before 2006, but now there are 13 states that have enacted harsher laws along those lines in the last decade. And again, those laws disenfranchise people who don't have those documents, but that's not a random sampling. People who don't have those documents are disproportionately likely to be people of color, very young or very old, people with disabilities, and as well as transgender people. That's not the only kind of restriction the legislatures who come up with this get creative. Requiring documented proof of citizenship, again, documents that a lot of people don't have, including women who've changed their names on marriage. Restrictions on voter registration drives, including making activities criminal with jail sentences. Aggressively purging voters, cutting down on early voting periods, eliminating polling places, which again tends to happen in communities of color and low-income communities. And this has been in the news lately. We've seen in Georgia where Brian Kemp is both the Secretary of State running the election and the candidate for governor running in the election, has used an exact match rule for names and signatures to throw out absentee ballots en masse. That policy has been stopped by an ACLU lawsuit just in the last couple weeks. And in North Dakota, where a new voter ID law requires a residential address as a part of the registration process, and tribal communities on reservations tend not to have residential addresses. They use P.O. boxes, so they're sort of en masse disenfranchised by this. That was challenged but upheld, and the tribal communities are obviously scrambling to comply. But it's not all bad news. I'm happy to say. Many states have advanced policies recently to expand voter access, and pro-democracy initiatives have been popular in ballot initiatives where people are sidestepping the legislature. So one of our priorities in the world of voting is automatic voter registration, or AVR. Voter registration itself derives from the Jim Crow era and was intentionally used to keep African Americans from voting. It still has disproportionate effects today. It's sort of unheard of in other countries, other advanced democracies. They just let everybody vote. So AVR, the concept is that anyone who interacts with a government agency is automatically registered to vote unless they opt out, and it's all computerized and sent to various agencies and updated automatically as people move. This has seen a big success lately with 9 states and DC enacting it since Oregon was first in 2015, so this has really been a wave just lately. And there are bills in many more states as well as Congress. And then another issue where we've seen or hopefully will see soon, movement is voting rights restoration. There are currently 6.1 million Americans who are not allowed to vote because of a felony conviction. 4.7 million of those are out of prison, completely served their sentence, just working and living in communities. These laws too began as an explicit Jim Crow tactic to stop African Americans from voting, and absolutely maintain that character today. Nationwide, 22.2 million Americans are disenfranchised, 1 in 13 people. And for African American men specifically, the rate is 7 times the national average. So in Florida, on election day, Floridians are going to vote on a constitutional amendment, which is the only voter initiative in the state that would dramatically reduce their felon disenfranchisement law, essentially making everybody automatically able to vote with certain exceptions. The current process, Florida is one of 3 states that permanently disenfranchises people upon felony conviction, and you can get your rights back through an ad hoc process where you go before a committee that is the governor, the attorney general, and another state, basically the 3 highest elected officials in the state. You have to get those 3 people in a room, and then people literally tell their stories on an individual basis, and the panel says yes or no. And the Palm Beach Post just released an investigation this week showing that Rick Scott has had the highest rate of the people that he has granted voting rights back to, the highest rate of whites and Republicans in many decades in the state. So, you know, this ad hoc process is obviously still being manipulated for political purposes. But if Amendment 4 passes on Election Day, which requires a supermajority of 60%, that policy will be completely reformed. The Brennan Center has been working with an organization called Second Chances Florida on this, and you can volunteer with them. They're doing phone banking remotely, so to try and get out the vote in the affected communities. I do want to talk briefly to go beyond voting, because much of my work is on campaign finance rather than voting, and obviously there are issues of equality there. Recent deregulation, especially the 2010 Citizens United decision by the Supreme Court, has led to more big money from a smaller number of wealthy donors than ever before in the modern era. As elections have gotten more expensive, I think a lot of people don't realize this. We always see the total price tag of elections is going up. Spending by candidates and parties has actually stayed relatively the same. The expansion has come from super PACs and nonprofits, these outside groups that are not subject to the contribution limits that are a fundamental pillar of the campaign finance system, and obviously are there to protect equality. I mean, it's sort of interesting. There's Robert Munch wrote a sort of historical book about campaign finance, and according to his story, equality was always understood to be the point of campaign finance rules. That's why you have contribution limits. That's why you have disclosure to tell who's doing what. That's why you would have expenditure limits if that were constitutional. But in the post-Watergate era, the first time the Supreme Court got their hands on those rules, in Buckley against Vallejo, they said equality is completely off limits as a matter of regulating campaign finance. It's not a permissible government interest. So that's the world jurisprudentially that we've been living in for 40 years, even though I think it's still intuitive that campaign finance limits are about equality, and we've now seen the effects of reducing those limits dramatically increased the spending by a tiny proportion of very rich people with this part's harder to prove empirically, but seems very intuitive, a corresponding increase in the political power of those few wealthy individuals at the expense of the political power of, the other 99% of the population. And this is, I'll just note, since this is the Hayes reunion, I was the Linfield Fellow and worked on First Amendment issues, so this is still relevant to my work today. It's kind of a weird dynamic where the people on the other side of the V from us are the ones who are saying, I'm the civil liberties lawyer and I'm going to get this law struck down under the First Amendment, and we tend to be the ones saying, no, 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 we're defending the law as not violating anyone's civil liberties. But I do think it's worth, and maybe we can, have that conversation in the Q&A if people are interested, but, I personally think there isn't a free speech right in spending $10 million on elections, but there are First Amendment issues in having a functioning democracy and having everyone have a voice that's not going to be drowned out by the few wealthy people at the top. So I think I'll stop there since I'm close enough to time. Thank you.
So I still think that there's room for hope, although it's still a lot of depressing stuff in there. And we do want to open it up for questions from the group, and I might just take moderator's prerogative and start off, because I heard a couple of things through each of the presentations. This idea of history repeating itself, and repeating itself in a way that is designed to divide, and the need for strategies that are unifying among the groups that are under attack, and this notion in the first two presentations about the use of narratives and rhetoric and language in ways that are divisive and that undermine progress and take away rights. And also the idea in the last two presentations of structures and the ways in which those structures are being used, again, to roll back progress. And so, and the idea of basic human dignity is something that's underlying it. And I just wanted, I wondered if the panelists can talk a little bit about, from those perspectives and based on the presentations that you gave, sort of what are some of the ideas about, strategies for unifying us in fighting on all these fronts, and sort of basically the idea of where do we go and how do we go together on all of these fronts. Like, what are some ideas for how to move forward in that way? Thoughts about, and again, just not us. I think that we ought to be drawing on. We've got a Hayes Fellows program that has been developing social justice lawyers over the years. What are some of the kinds of things that we think should be recommended as we move forward as social justice lawyers and law students going forward? So I might open it up with that. You guys weren't supposed to be the cricket.
Oh, great. I think one of the things definitely that has been, restoring hope or faith is actually not legal at all. I'll admit, I was actually personally, when the first travel ban came out, and we all knew it was in the works, I did not expect people to turn up at the airports and be offended. Like, I was like literally in tears. I could not believe the number of just average, or even, but I don't want to discredit also folks who organize and advocates were able to get people there over a sustained period of time. And, I will also, clearly I'm not here in my official capacity, but I say absolutely, the fact that there were crowds there is partly what motivated the Attorney General's office to get involved. I mean, it is ultimately also an elected official who runs that office, but that public outcry absolutely made a difference. So I think, the point about the community organizing and getting people out there, I feel like having worked in this office, for the government, I actually do see just how, even if it's for kind of cynical or jaded reasons of getting votes, but as a real practical matter, the getting out there actually totally makes a difference, totally makes a difference.
Gabriel?
So the questions are, how do we work together, and what should the Hayes program do?
Well, sort of, where do we go, how do we go together? And then with sort of as a way of thinking, and I'm kind of building off of something that you said, Gabriel, which was this idea of having a strategy that is unifying among those being excluded. You know, that one of the things that we're seeing that's so insidious, I think, is that there's this narrative out there, there's this rhetoric out there that is really about, well, there's so much of it, it's like a fire hose in terms of the attacks, and it's also about dividing communities and individuals who actually should be joined together, and also about getting people to kind of move forward in some ways that we see as against their own interests. And so sort of, so that there's a piece that's about sort of narrative and rhetoric, and how do we combat that and do it in a way that helps us to move forward, and how do we go together? And then what are some of the strategies? I mean, community organizing, I think, is really one of them, right? So really tapping into communities. I think voting is a big one, right? We have a few days before we find out what happens, I don't know. But as we think about it, as social justice lawyers, like moving forward, we're looking at the courts, it's not looking so good. What is it? Is it more policy work? I mean, I was really encouraged by Susan Shin's work with the New Economy Project about structures, like really thinking differently about structures in the economy. And so, you know, I'm just asking, you know, thinking together and hearing the work that each one of us is doing on building equality and equity, like what are some of the thoughts that you have about how to actually move forward in that way, strategies that are unifying, and then how do we inform the Hayes program going forward? I mean, we're continuing to do work with law students, right, around these strategies. So what are our thoughts? I mean, trying to keep in that fighting mode. What are the ways that we think the fight will be more likely to be successful, even against the odds that we're facing?
Well, one thing that I do wish that I had learned more about in law school, if not before, was the history of social movements and the role of lawyers in social movements. And I feel like, you know, we got a bit of that in the Hayes program, but there could be more, I think, which would be helpful. I was also thinking about how history repeating itself, and in 1901, Murray Hamilton Hall died. He was a Tammany Hall politician, and when he died, the coroner discovered that he had a vulva and told the world, and there were national headlines about it. And some people were saying, well, look, this proves sex equality, and there is a case for women's suffrage. The New York Times, though, reported a proposal from some people that Tammany captains should have to show whiskers on their face just to make sure that no other women sneak in and vote. And you know, that proposal was like laughed out. Like nobody actually like took that up. It was not passed at all. And like they're proposing. And now I just read a Times story that is about like another ridiculous, terrible proposal that is about excluding trans people from public participation and keeping women in their place. And what feels scary is that it's not so clear that it's just getting laughed away, right? But I do think that there's something like, you know, this is not the first time any of this stuff has happened. I mean, it's different now. It's different in many significant ways. But there are things that I think we can learn when we look more at histories, and especially the histories of movements. So how we move forward together, I think it's a combination of, I mean, it's really just showing up for each other, right? Without necessarily expecting something in return, listening to people, even when we disagree with them, but also not being afraid to say when people are hurting us, and listening when people are saying that they're hurting us. I also just, you know, like I work at the ACLU, so I work pretty long hours focusing on these issues in a particular way. And it never feels like enough. Nothing ever feels like enough. And so I've been thinking about, you know, what else can I do? And I've been trying to focus on what else I can do that really will sort of also give me more energy rather than taking it away, which may be different for everyone. But for me, you know, in 1 week, I volunteered sending legal information to incarcerated trans people around the country. And then I also went to a fundraiser for All Costs, an LGBT Palestinian group. And then I also went to a protest to make the subway system in New York City more accessible. And the one that happened to like really give me more energy rather than less was the showing up before the protest. So I'm looking at, if there are more things that I can do that will actually give me more energy rather than less to do my other work, that's great, right? So I think trying to look out for those things that aren't going to burn us out, but actually feed us and still do more in different ways, that's great. I feel like more specifically, right now, let's all encourage anyone in Florida to vote yes on 4, and let's encourage anyone in Massachusetts to vote yes on 3. That in Massachusetts, there's a ballot initiative where people are trying to revoke anti-discrimination protections for trans people. You vote yes on 3 to keep them the way they are. So let's all try and encourage people in Massachusetts and Florida to vote in those campaigns. And I would love to hear how we can help out with that public bank, which sounds amazing.
Yes. I think you're not alone in that. I think a lot of us want to hear more about that public bank.
Right, so how you can all help support our public bank campaign. But we're really excited about that. I think the idea that New York City has so much money and that's just being extracted or taken away from New York City communities and being really used to help Wall Street banks profit when Wall Street banks are doing so much to damage those very communities. The fact that we can talk about all of the things that the banks are doing, I think, is one way for us to connect the dots for a lot of different issues that people are working on. So I really liked hearing when Gabriel said, we have to talk about climate justice too when we're talking about gender justice. I think because so many things relate to one another, and one of the principles underlying our work is also ecological sustainability. So we're trying to be very cognizant of that and trying to articulate that all the time to remind people that there are all of these connections. And it's really hard because, there's so much to do in your area and you get very siloed and very focused on that. But I think to the extent that we can keep reminding each other and, have opportunities to come together and connect those dots, then that will help us stay unified.
Yeah, I think that's absolutely right. And I think it does feel to me like in my long public interest career so far that there's been more of a feeling of less sort of siloing and feeling of like we're all in this together. And yet I see that with, I work on political process issues, which is like the least sexy thing there is. But now with, one political party systematically, changing political processes to take power and then use that power to harm marginalized communities in a very intentional way, I feel more and more people understanding that these fights about voting, campaign finance, and redistricting are all of our fights, and other issues are not going to proceed without progress on them. Not to say that what I work on is more important than everybody else. The opposite, to say that it's all connected and it all sort of has to go up at the same time.
I actually have a question for Susan.
Oh, good.
I'm wondering, this notion of like creating alternative institutions and structures, like it's great, and you see it also in like community policing notions and dispute resolution. And I'm wondering if, have you encountered resistance or like active opposition from kind of the established institutions that you would be challenging? Like, what's been the nature of that? How do you deal with that? Maybe that's a really long answer, but.
Well, it probably won't surprise you that the answer is yes. For instance, our campaign to promote community land trusts, there is one very long-standing community land trust in New York City, Cooper Square, and it has a really long history of organizing, and they faced all sorts of obstacles along the way. It took a really long time. Now we're at this point where we've always had an affordable housing crisis, but we really have an affordable housing crisis, and not just for low-income people, but very low-income people, extremely low-income people, homeless people. And so we really want to make these community land trusts happen a lot more quickly than it took Cooper Square. And we have obstacles in the form of, the city and the city agencies saying, no, this is the way we've done things, and, what you're trying to do doesn't fit into our boxes. So there's a lot of organizing that has to happen to overcome that. On that kind of front, I mean, yes, litigation, people have said it's not the only tool. It's not a tool that really, I think, fits this campaign, but community organizing is especially important, I think, on the CLT issue. And, there's landlords and developers, I mean, kind of the biggest obstacles you can imagine, who don't want to see any of this happen because they just want the things to work the way they've been working, because that's how they have been making huge profits. But we want to see a city where people can afford to stay here. And increasingly it seems like an impossible thing, but it's been really encouraging and uplifting to see how this effort that started, how many years ago now? 2013, 5 years ago, I think, Sarah. That at a time where no one was really talking about CLTs, and now we're at a place where the city is talking about CLTs. They've got people at the city's housing agency talking about CLTs and what we can do about them. You've got all of these different community groups around the city saying, we want to start a CLT. We've got CLTs that have started. So it's really exciting. It's a long haul, and the public bank also will not happen tomorrow by any stretch. But I think that's the resistance that we have to keep performing. So
you have to keep that work going. Again, I want to open the floor up for questions from the audience. Yes.
So I wanted to ask.
I got it.
I wanted to ask Ian some questions related to electoral issues. So where do you think we stand with respect to commissions being established for the reapportionment process? One of the concerns I have is that in some of the Democratic states, I think there are going to be gubernatorial races that are going to be helpful, particularly in the Midwest and so on. And I just wonder, Democrats may be interested in good government, so they may want to create commissions, and yet in a place like Texas, they're going to gerrymander like crazy. I wonder if you talk a little bit about that. One other question, and that is, what's the current status and effectiveness of the motor voter laws that was enacted quite a while ago? Does it have any vibrance today?
Thanks. So, second question first. Motor voter law is still something that gets used in litigation. It's still, the find states with HAVA violations for not making voter registration adequately available at DMVs. But clearly, we think that the automatic voter registration, which is also sort of connected to motor voter in that the DMV is the main point of contact with governments that would make people get registered, would be a vast improvement. On commissions, that is, so having an independent, bipartisan commission that draws redistricting lines is the sort of best practices reform. There are a few states that already have it. There are voter referendum movements in several states to get it. It tends not to be the kind of thing that a legislature will pass. Gerrymandering is a Democratic and a Republican practice. Republicans have been better at it lately. I don't have the list of states where it's pending on the top of my head, but that is a reform that's definitely moving.
Other questions from the audience?
So, identify yourself. Hi, I'm Sarah. I'm a current Hayes Fellow. Thank you all. This is really, really interesting. And also, there was a lot of inspiring moments in the Depression, so thank you for that. So one of the things a lot of people mentioned were the different tools that we can use to make change. And I think 3 people mentioned community organizing and all of that. And so I was wondering, what, in your opinion, is the role of the lawyer in community organizing and social movements? And then also, there are big impact litigation organizations that are starting to think about community organizing, whether it's through initiatives like People Power or expanding membership and that kind of thing. How do those intersect, and what is the role of the lawyer? If maybe, is there one? Should there not be one? Thank you.
So I'll take a stab at that, and hopefully people can add. So one is that in a community organizing effort, unless it's, say, that lawyers want to work on some issue that is specific to the legal profession, like we want to reform the rules of admissibility or something. In general, if it's organizing around any issue that is not directly about lawyers, then lawyers shouldn't actually get to say what the role of the lawyers are. Does that make sense, right? I mean, generally, and that can be a risk, is that sometimes lawyers can take over, which can actually sap the power of community organizing, which, like, community organizing is supposed to be by and for communities themselves shifting power, taking power, defining what they need, and making moves to get it. And sometimes lawyers are a part of the relevant community. But when we're acting as lawyers, we need to be careful not to take over. That said, I think lawyers can play a variety of important roles. Some of the roles that people have asked me to play as a lawyer in community organizing has been to organize legal support for protests and people who get arrested as a result of direct actions. People have also asked me to help train people on analyzing proposed language in bills. That's not a skill unique to lawyers, but it is something that we're generally well suited to do, and we can share those skills. And that can sometimes also involve helping people to identify targets. So if people have a campaign in mind but aren't sure who the ultimate decision maker is, that's something we can sometimes help people unravel. It's somewhat gross, but sometimes I've been asked to sort of give credibility to other people by being a lawyer. I was once doing legislative testimony in Massachusetts for a bill that would dramatically restrict solitary confinement, and I was on a panel testifying with 3 LGBT people who had been formerly incarcerated and held in solitary confinement. I was the only person there who had not been formally incarcerated, who had never experienced solitary confinement. But when I spoke and said that I was a professor at Northeastern Law, the commissioner actually, the chairperson of the committee actually went, I mean, it was so visible, the attention that I got. And so while I don't actually think that the content of my remarks is giving anything at all more useful than what my co-panelists who had actually experienced solitary confinement were saying, I do think that I was sort of able to add some credibility. And it's gross that our system works like that, but it's a use of our position that can sometimes be useful. Sometimes people have also asked me when I'm doing intakes on particular, with people in particular communities, if I can offer people information about community organizing projects that they might want to get involved in. So I've sometimes done that. So at the ACLU now, I do plaintiff searches, which I didn't do back in direct services land, right? And so that also often involves calling up a lot of organizations, including community organizations, and saying, hey, is there anyone who is having this problem and who might want to sue about it, essentially? And I also always try to ask, and is there anything that we could do for you? Is there, whether that's, so sometimes that just means like someone will say, yes, could you please let people in your office know about our fundraiser? I'm like, sure, I can do that very easily, right? So sort of I don't know. I think that there are a wide range of different things that we can do in terms of community organizing where our legal skills can be helpful. And we just need to make sure that we're not trying to make the decisions about how to, we're not trying to make all of the decisions or the decisions about how we're going to be involved as lawyers.
I'm just going to jump in. I mean, I think totally when it comes to the context of working with community groups or actually anyone, you know, we are called counselors for a reason, right? Like we want to be able to tell people what the risks are of whatever they're doing, whether it's civil disobedience or they want to undertake creating brand new institutions in their communities. Like, well, this is what you might happen and what might not, and leave the decision-making power with them. I'm also going to like make a little plug. And I think my law school mate would not believe that I'm saying this, but I would make a plug also for impact litigation to the extent that, look, sometimes the movements don't exist, right? And to me, the most compelling recent, or one of the most compelling recent examples of that were the Guantanamo litigation. There wasn't in 2001, 2002, when these cases were brought, that ended up like 4 or 5 years later, like Rasul, there was no movement. There was no massive public outcry to get these people counsel. And the fact that lawyers nonetheless took up that mantle and went in for it. And I think that was a different, that's one of those situations where kind of the organizing came afterwards and was sustained, and there were campaigns, I'd say more like campaigns than actually organizing, so to speak, around it, that continues to this day. But to answer your question, I think, you know, second what Gabriel said.
And I would just briefly add, it's a really rich question because there's a lot, I know in our clinics we have conversations about the role of the lawyer within the context of community organizing. And there are some really deep and careful conversations that have to have about, given the degree of, you know, lawyers like to go in and we're going to go in and fix things and we're going to, you know, we can tell you what the risks are, et cetera. Balancing that with an idea of really organic community organizing when we say we are trying to empower a community, that we have to mean it, and that has to really involve a very thoughtful way of checking what's the appropriate role of the lawyer, what's the scope and limits, and how do we rethink, and who is our client, and all of those questions. I mean, it really is a deep question and one that should be asked all the time. And so, you know, I really do think it is an important question and one that comes up a lot in this context of community organizing, especially where there's such a need to have buy-in and leadership from the communities that you're serving and that are excluded in other circumstances. That's a really good question. I don't know if anybody else wants to repeat that. Next question.
Well, mine's more of a comment, and I don't want to be one of these people who gets up to ask a question and then sneaks in a comment, so only if it's permitted. I'm Mark Risk, class of '84, and I was here during the first Reagan term. And by the way, one of my favorite Norman Dawson quotes was, he said, you know, people talk about how great the 60s were. What the 60s brought us were Nixon and Reagan, he said. Never mind that. But what I would like to say, and thanks for a great panel, what I want to add on top of it is, I think, a huge part of the American story since the first Reagan term is the hollowing out of blue-collar America. And, you know, it's been, those communities have been hiding in plain sight. We drive through them in state after state, and it looks like a bomb hit them. And I'm told, speaking of voting, that if you take out New York and California, Mr. Trump won the popular vote by 3 million votes in the remaining 48 states, which is quite a profound thing. So to me, one of the hardest problems of the current political situation is, you know, we have this tragedy now where the various minority communities that you all are talking about are on the other side of the net from blue-collar communities where people correctly think that the plant is closed, our kids have no future, and on top of that are you know, the social pathologies that come with that, particularly drugs. And so for me, the hard problem is how to find a politics that gets all these people on the same side.
Yeah, and I think, and so it's an interesting observation, because I think it goes to the question about how do we go together because the narratives and rhetorics that's being used is effectively like driving that wedge, even though the interests, I think, the concerns about economic inequality, about what's happening in real life across the country, does involve all, communities, vast majority of communities across the country. But I'll leave it to the panel to respond. Do you have responses to that?
I mean, I do think that it's, what you're saying is absolutely true. And it's not true that the entire white working class supported Trump, right? And it is also true that there are members of the working class who are people of color, Muslims, trans, women, right, and so on. And so I think that, from my perspective, I don't think that it's my role to go out as a New York lawyer and have a lot of conversation with white-collar workers in the Midwest or mountain states and try to tell them what they should believe. But I am interested in how I can support people who are part of those communities and who are doing progressive organizing in those communities. And remembering that there's always overlap, right? And sometimes, like after Orlando, there was a moment when a lot of LGBT organizations and a lot of Muslim organizations wanted to start talking to each other more. And one thing that some of us who are LGBT Muslims were like, why is nobody talking to the LGBT Muslim organizations? Like, we're here too, right? It was still good. It was still good that the LGBT organizations and the Muslim organizations were talking to each other. But there are always people in the intersections, and we should be thinking about ways that, what ways are they asking for support from outsiders? And what bridges can we build? It's not a full answer, but I do think that there are things that are already starting. We don't need to feel like it's on us to come up with it all. We can support people who are coming up with it in different places. I don't know. What do you think?
I'm actually, it's something what you said at the end of your talk, which is, and Van Jones kind of, and others, but Van Jones is the name that I associate with this, took a stab at this in California 10 years ago maybe, but environmental causes, right? Climate, and not climate change necessarily writ large, but trying to, in terms of both create jobs or generate jobs that are, as well as raise awareness, but also, these are issues that cut across for a lot of folks. Different axes of identity. I'm trying not to laugh because if anyone watches Veep, I hate saying green jobs, but that's immediately what I think of. But anyway, there was this real effort to be like, folks got together and be like, okay, this is the issue. This is the issue, what we can do. The reality, though, also is like, we still live in a really racist, homophobic society, and I'm not saying like these efforts have failed, but I think, we can't underestimate kind of the other divides that exist. But I think that's folks who are looking for how do we get that commonality. I think a lot of hope does potentially lie in climate justice.
Come up to the mic.
Hi. Robert Van Lierop. I guess I'm shorter than I thought, but I'm shrinking. I have a slightly different view about where we stand today. All day long we've been hearing dire talk about where things stand, but I look back at when I came to this law school. By the way, I was the only person of color in my class. There were maybe 15 to 20 women, but I was the only person of color. And in those days, many students were afraid to demonstrate against the war in Vietnam and for civil rights and other things because of the Character and Fitness Committee and admission to the bar. Even getting into law schools was difficult if you had been an activist and had been engaged in protests. I want to ask Ian what the Brennan Center might have a view of in terms of the rights of convicted felons to practice law, even to get into law schools nowadays, because the legal profession has always been very conservative about those things. Edwina Martin and I, when we practiced together, had a very brilliant guy who had been a jailhouse lawyer and went to law school, and we had a big fight to get him admitted. He's now doing very, very well as a practicing attorney. And just want to hear what the Brennan Center has to say about that. And then maybe when everyone leaves here, they might feel a little bit more uplifted if they ask themselves a question that if the Creator, in her infinite wisdom, gave us a choice of being either a slave or a slave owner, which would we choose and why? But Ian, please. Yes, environmental justice, I feel, is going to be the cutting edge. Then that's the next big battle that we will win. And I take the Robert De Niro view of the current occupant of the White House, so don't worry about him.
Thank you. Part of me wants to say I work for the Brennan Center's Democracy Program, and this is a question for the Brennan Center's Justice Program. The Brennan Center has been involved in the sort of ban the box movement, meaning get rid of this like automatic question about arrests or convictions as a part of employment applications, because it's frequently not relevant and it just becomes a like red flag, sort of scarlet letter type thing. I think the same principle applies when it comes to the legal profession. I think the Americans' thoughts about criminal justice are contradictory in many ways, but one of them is this idea that you have a sentence that you serve, then that's justice. But then at the same time, even after the completion of that, there's still a mark somehow that lasts forever, and that's who you are. And I think, we certainly need to move away. I'm definitely speaking out of turn now from the latter half, and potentially also from the former half of the idea of what justice is in terms of incarceration and other criminal sentences. But at the very least, it should be sort of rationally related, and most crimes, frankly, aren't rationally related to the practice of law. Embezzlement, maybe, is one you should look at closely. But like I said, I would refer you to my better informed colleagues in the justice program, but I do think the principles are at least at a high level are the same.
And actually,
One problem, and you might want to know, I don't know if Barbara Gillers is here or Steve Gillers is still here. They were. But they were here. But NYU just last week had an inaugural reception for a fellowship that has been started with alum money for a former incarcerated person who applied to law school and to attend the law school. So the law school has acknowledged the issue and is beginning to take steps, and there are alums who have done criminal defense work who are putting money behind the problem. So it's
and I would also add, it's also something that is not even under existing rules, not insurmountable necessarily. CUNY Law School has a recent graduate, an alumnus, who was incarcerated and so got advocacy assistance in connection with the application to law school, assistance through law school, and real advocacy at the end, going through that character and fitness process to persuade, right, those who were in charge of that process that have had that, right? So there is a role for advocacy even under the existing conditions to be able to, in given cases, have those who are formerly incarcerated actually succeed, as difficult as it is, through that process.
as well as the undocumented.
Yes, I mean, we've had success as well with DACA, although now we're kind of in this odd spot.
Admitted to the bar of the state of California is a person who is not, by the Supreme Court of California under a statute authorizing that admission.
And as well in New York, we have a recent graduate, Cesar Vargas, who also was undocumented, documented student. And we've made some headway in terms of licensure for DACA, et cetera. But again, that's on shaky ground at this time. But I guess the answer is really not only, sort of advocating for structural changes going forward, but advocacy even within the current limits to get that done where possible. Are we at time? We are at time. Thank you so much. Join me in thanking this panel for a wonderful discussion. It is time for cookies and coffee and fruit and other stuff. Enjoy.